If I can have your attention, I think we're about ready to begin, and maybe we can close the door at the back of the room. It is indeed a great pleasure to introduce our Frey lecturer this year, Professor Pamela Samuelson, who is Chancellor's Professor of Information Management and Law at the University of California, Berkeley. I think most of us here already understand, in fact, that Pam Samuelson is among the very best intellectual property scholars of our time. She holds joint appointments to the Bolt Hall faculty and in the School of Information Management and Systems at Berkeley. She's co-director of the Berkeley Center for Law and Technology. She's founder and advisor to the Samuelson Law, Technology, and Public Policy Clinic at Berkeley. She is a fellow of the John D. and Catherine T. MacArthur Foundation, a distinction that most of us refer to as a MacArthur Genius Award. She is an honorary professor at the University of Amsterdam, a member of the boards of directors of Open Source, Public Knowledge, and the Electronic Frontier Foundations. She has been identified as one of the 11 technology pioneers by the Wall Street Journal and as one of the 100 most influential people in the digital age. I am by now, of course, reduced to sampling among her numerous credits and awards in the interest of time. Perhaps I should summarize them still further by saying that she is a very big deal. This has not come about by accident, however, and I will be justified, I think, in spending a moment or two more in explaining why this is so and how it has come to be. To begin with, she has been a prolific writer with scores of articles and essays and books and entries in books to her credit. Scores may, in fact, not be quite the word, it may be hundreds, but in fact, very, very many. Thanks in no small part to this remarkable body of published work, she has been the leader in shaping the way we think about computer law. Years ago, she saw, as few others did in that time, that we'd begun to draw unwise and even destructive analogies between certain established doctrines in copyright or patent law on the one hand, and the means of embodiment of ideas and expression in the new computer field on the other. And she set about resolutely to correct our mistaken impressions, our erroneous judgments, and our wrong conclusions. She did this at first by writing squarely against the grain of such opinion as then prevailed, and she continued to write powerfully and persistently until finally one could fairly say that she herself, working almost entirely alone among legal academics, had reshaped our thinking so persuasively that the grain of informed opinion at large had at last begun to parallel her own. This was an heroic achievement, in my view, and not merely because it meant waging a vital but difficult struggle against entrenched adversaries, but because it meant as well a life of the loneliest sort of scholarship imaginable. As she herself once observed in my hearing about the work of another, those who oppose the conventional wisdom are rarely appreciated for their temerity, and it is fair to say that Pamela Samuelson went too much unappreciated for just enough years in that long ago time that a less resolute individual might have been pardoned for abandoning the effort and turning to something more immediately likely to produce measurable results. It is to her great credit and to our ultimate benefit that she persisted, for the fact is, as even her continuing adversaries must reckon with now as a fait accompli, the fact is, as I say, that she now appears to have been right all along about the conceptual anomalies she identified and about the baleful consequences that would have followed if we did not come to terms with them. What began as concerns for copyright and patent law in the context of computers, however, expanded along the way to include other doctrinal fields within the landscape of intellectual property at large and the entire array of new technologies. Today it can be fairly said that no part of the convergence between law and technology remains uninfluenced by Pam Samuelson's pioneering work. Her work has shaped the issues we discuss when we discuss law and technology. Hers is still a leading voice among a rising chorus. She has survived the difficult early years, and far more than that, she has triumphed magnificently. In numerous other ways, perhaps less dramatic, but no less important still, she has joined others in efforts to preserve and reestablish the necessary boundaries between aspects of expression that may fairly be the subject of exclusivity and those that should remain within the province of fair use or the public domain, or fall within the orbit of expression protected by the First Amendment. She has written numerous amicus briefs, including, I should add, an important brief in the Grokster case to be argued very soon, within a matter of days, in the Supreme Court, while also offering testimony, speeches, and public appearances, the main point or underlying theme of which in each case has been this: that in a world increasingly shaped by the advent of new technologies, we must be all the more vigilant against efforts to expand the reach of established intellectual property doctrines in such fashion as to impede the flow of information and ideas that these new technologies promise to make free. Her lecture today is about about enriching our discourses in the public domain. You can see I anticipate your remarks. I can think of no one who is more qualified to speak to that subject than our friend and our colleague, Pamela Samuelson.
So I prepared a slide of thank yous, and I have to start actually with thank you for that excessively generous introduction, David. But I am very grateful for the honor of being here and to be able to give this lecture. So thank you to the Freys for making this possible. And I want to also, at least some of you know this, but it's always good to hear it from an outsider, that the Duke Intellectual Property faculty have been exceptionally generative in the field of intellectual property law by really starting this attention to the public domain. And so they themselves have written incredibly important contributions, starting with David Lange's essay back in, I think it was 1981. And through the conferences that they organize. And so part of actually what's worth celebrating is not only have they written things that are important in this area, but they have essentially inspired other people to do the same, both through the two extraordinary conferences that have been held here, but also they got excited people in Europe. So the University of Amsterdam held a public domain conference, and it is about to publish a set of essays that will further this conversation about the public domain. And a few of the essays I'll touch on in that book, I'll touch on because it just shows that this scholarship is really blooming and is going to continue, I think, for some time. And they haven't been willing just to say, oh, well, let's write scholarship or let's hold conferences. They're also working to develop and to foster institutions that actually are promoting public domain interests, whether it's the Center for the Public Domain, Creative Commons, on whose board Jamie serves, Public Knowledge, with which we are both affiliated. So this really is an extraordinary thing to have gotten started, and so I'm blessed by first the chance to come here a couple of years ago and talk about my own first foray into public domain scholarship as such was actually my contribution to the 2002 conference. And I decided that what was needed was a map of the public domain because there were too many works that I read that sort of talked about some aspect of the public domain and kind of didn't seem to realize there's other stuff in there too. And maybe actually if we had a richer understanding of the stuff that was inside the public domain in this map, then we would be able to essentially understand it better. So it had a descriptive value so that we'd sort of make sure that we weren't concentrating only on this one little sector, that we were really understanding the richness of it. It had this normative value of articulating the values and reasons to preserve it, and then a political value. So it was my essay subtitled Threats and Opportunities, and really was trying to think about ways in which the public domain was under threat and what opportunities there were to do things to promote the public domain. And that was really a fun exercise for me. And this is my map. Now it's not that pretty. And of course, because it all has to fit on a computer screen, doesn't have all the stuff in the public domain that really belongs there. But these were at least some of the categories. And sort of in retrospect, thinking about it, I've sort of realized that there were some assumptions built into that map that I should question. So the first assumption was the map assumed that there was one public domain, namely the one that I mapped. Okay. And I defined that public domain as intellectual property people are wont to do by information resources that were unencumbered by intellectual property rights. And so I accommodated other people's definitions, such as Yochai Benkler, by saying, well, there's this contiguous space over here, open source, widely usable without restriction and fair use and other privileged uses. And so for those people, that public domain kind of extends a little bit farther into that other reach. But nevertheless, the implicit sort of assumption was that my map was the right map and that other people were using the word public domain in like a loose way, and that, that they shouldn't do that, right? So I didn't say it in public, but, open source software is not public domain, okay, just so you know. I didn't want to start a religious war about this, so I just polite and kind of let people use this word loosely when I thought that was a good thing to do for the community of scholars. But I also didn't map anything about an information commons. Now, that word was coming to be used sometimes synonymously with public domain and sometimes in a different way. And so I didn't map it because I didn't kind of know what it meant. I was unclear on the concept, right? To what extent did it overlap with public domain? And was this really a public relations ploy, right? So I thought, that was actually when I came to your conference, Jamie, I thought, it's like, oh, okay, public domain, that's the old word. That's like boring, it's tired. And commons is wired, it's like the cool new term. And so it'll kind of get everybody's kind of juices flowing, not to use that sort of staid old word. And so I was okay with me. But to the extent that it's a public relations ploy, why would I put it in my map, right? Okay, so a very profound shift happened, and it actually happened more recently than I like to admit, which is going back and sort of reflecting on my map and on other things that were a part of the Duke conference. I sort of recognized that, Jamie has been saying for years that there isn't one public domain. There are many public domains. And so this kind of was, this sort of willingness to like entertain the possibility that there was like more than one definition was not something that I initially was like really keen on. And so just, why can't right-minded people get together and like, let's define it and let's then, think of other terms for these other sort of things that we want to do. And wouldn't the law be really incoherent if you have public domain being used in too many different ways? And so I said to myself, nah, that's not a good idea. I'm not going to recognize it. But then James Boyle pointed out that, well, property scholars use property words, the property word, in multiple senses. And people don't get confused because there's actually, you can understand the use. When we're talking about this kind of property versus that kind of property, you can tell in terms of context. And so maybe the thing that we need to do is that rather than trying to sort of force everybody to have one definition of public domain, let's articulate what multiple public domains might look like, and then try to develop a richer vocabulary about what those things mean and the context within which we might want to use them, and what's the conceptual structure for understanding these, and what difference does it make. So the principal goal then of the lecture that I offer today is my effort to sort of accept more than one meaning for public domain and think about it. Now, I'm not going to go through this slide, but all of you who've taken property know that James Boyle is right, that we use property in multiple contexts. And so the idea that something like public domain could be used in multiple contexts doesn't seem absurd on its face, given that other bodies of law, including property, has multiple meanings. So what are the many public domains? Some of these are touched on in the second enclosure article and other articles that were in the Duke volume, but I've identified what I say was kind of 7 of them here. And I'll kind of talk through them briefly, and then talk about, what is the payoff if you accept that it's legitimate for any of these entities to use the word public domain and not freak out. So the sort of the easy categories of things to say are public domain, and I think these things are public domain for everybody. So some of these definitions of public domain sort of overlap with others, but certainly information artifacts that don't satisfy intellectual property requirements or that are subject to expired rights, those things are in the IP-free meaning of public domain. And interestingly, Supreme Court decisions recently in the Daystar and Traffics cases suggest that if you have works that are subject to an expired copyright or an expired patent, that you can't kind of use a neighboring body of law to essentially reclaim the interest. And so that actually suggests that there's some things that are in the public domain and have to stay there, right? And so part of the sort of interesting question that has been addressed in the literature in the last couple of years is, how much fluidity is there back and forth between the boundaries of intellectual property and public domains? And is that a good thing or a bad thing? And sometimes it's good, I think, and sometimes it's bad. But noting that some things have to stay in the public domain is kind of an interesting thing to observe. Now, most of the discussion about the kind of the expireds and the ineligibles don't really talk about this. What is to me a really interesting category of involuntary public domains, because a lot of the sort of talk is about dedicating something to the public domain, or after the rights expire, they fall into the public domain kind of automatically. But there are times actually when the public domain kind of captures things kind of across the border and puts them, they used to be on that side of the fence and then they come on this side of the fence involuntarily. And some of the leading trademarks have become essentially common generic terms in the trademark law, leaked trade secrets and so forth. There are actually lots of things, and I think these things that are involuntarily in the public domain, generally speaking, once they're there, they stay there, just like the expireds and the ineligibles. And yet, there is this kind of interesting question about whether if something has been for some period of time in the public domain, can it kind of get yanked back out by legislative action? And so there are many works of authorship from other countries that were published in the United States without copyright notices, and at the time that they were published, the failure to put the notice on meant that the work was dedicated to the public domain, partly in reliance on treaty obligations, or a theory that you had to do this in order to comply with the treaty. Congress passed a law that essentially restores foreign copyrights, takes things out of the public domain that were there for many years, and kind of makes them undead, right? Makes them new copyrights, and that actually is being challenged on constitutional grounds. And so that particular issue, I think, is going to be very important in terms of sort of what else might actually involuntarily be taken out, but then able to get back into intellectual property. Now, ideas and information are things that most commentators and most of the legal decisions say, of course, the ideas and the information and works of all sorts are actually, once publicly disclosed, in the public domain. There's a passage in Second Enclosures where James Boyle says, that's not public domain, that's something else. And so, again, it depends on what your definition of public domain is, whether ideas and information are in them. But I'm going to be conventional and say that at least in my public domain, their ideas and information are in the public domain. And recent work by Diane Zimmerman argues that actually there are some things that have to be in the public domain, that Congress cannot take some things out of of the public domain, that they were born in the public domain and they have to stay there, and other things, the expired copyrights and expired patents, they were on that side of the fence, but once they come on the public domain side of the fence, they have to stay there. And so she makes an argument that all of these things are things which Congress can't privatize, even if it was persuaded to do it. And her article on that is very interesting. It was published in the Fordham Law Review relatively recently. She defines these things as subject to a commons. So here's actually an example of a use of the word commons as a zone in which the uses are free in the sense of unrestricted and free as in uncompensated. And that's one meaning of commons that you find in the literature. I'm also really interested actually in things that have not yet been privatized in two senses. One is that I think that there are some things that actually temporarily are in the public domain and then go across the fence into intellectual property. Some of them will actually come back to the public domain, for example, after rights have expired. But I think this is actually a little corner of the public domain or parts of the public domain that has not been much recognized. So that, if you are a biotechnology researcher and you come up with you discover a gene sequence that has some therapeutic value, you go to a conference, you present your results, you publish an article about it. For the period of time before the patent issues, that actually, right there, the knowledge is publicly accessible and there's no patent, so there's no, in fact, right to exclude, but that's going to only be temporary. And there are lots of other things that are in the public domain that are going to kind of work their way over into one of the intellectual property rights. And I give a couple examples here. Right? Google was a word that you could have just said, well, it's a word in the public domain. It's kind of a funny word, but now it's a trademark, and so it's not in the public domain. And it may actually go back into the public domain, right, to the extent that it becomes a word that's put in dictionaries as an indicator of searches. And so I know the trademark lawyers at Google right now are working really hard because there's at least one dictionary that plans to use Google as a search term. But that raises another set of questions, the not yet privatized, which is also flows from the Zimmerman article, which is, are there things in the public domain that actually aren't privatized yet but could be? And I think that there are differences of opinion on the things that I'm listing here as to which of these things probably could be privatized by Congress if it so chose. I think easy ones are things like typefaces. You could actually create a little mini intellectual property system for it. It's no reason really to do that, but it's not like it would be unconstitutional to do it. Some of the other things that are in this list are actually things that people would fight about and have fought about. So the unoriginal database protection issue is one that many of us in this room have said, both on policy and on constitutional grounds, that Congress really can't do it, and we follow the Supreme Court's vision in the Feist versus Rural Publications case that Congress can't grant copyright-like rights to unoriginal works, such as collections of information. So I think two of the political goals of the public domain project in relation to these things that are not yet privatized are to persuade Congress to require that there be real empirical evidence of market failures before there is any privatization, future privatization from the public domain, and also to persuade them that some things really shouldn't be privatized either on policy or constitutional grounds. And I think we've actually made some progress on both of those things. The fact that the database legislation that we've followed for many years has in the last 8 years not been passed is really a sign that there's been some resonance with the concerns that have been raised both on policy and constitutional grounds. Now, the issue about what can and can't be public domain or privatized has given rise to this larger conversation in the international environment about whether or not really there are some things that are universally in the public domain, right? You can look at different countries and some things are in the public domain in this country but not in that country and vice versa. But the quest for trying to sort of understand, are there things that kind of should be in the public domain and are really conceived of as public domain things kind of in the world, and should we just have a treaty, among other things, that will protect that. That's actually a conversation that's getting started, and that's one of the reasons for the Amsterdam conference, was to further that conversation. And I think one of the things that effort and the effort of many of us who participated in the conference has really tried to do is identify a set of values that public domain in the IP-free sense serves, and to sort of say that not everything in the public domain serves all these values, but that there are a range of values, and some things serve more of this set of values than that set of values, but nevertheless, in a package, they serve some very important societal values. And this articulation of the positive values of the public domain is really an effort to sort of respond to what used to be this kind of void, right? This kind of negative. Well, it's not intellectual property rights protected, so it's kind of defined negatively. This is kind of an effort to define it in a more positive fashion. And I think that that's a really fruitful thing, and I'd like to see the values as well as the words in any international document about the public domain or public domains. And yet, I have to say that after reading Chandar and Sundar's criticism of the romance of the public domain, that even though I really like this idea of let's have treaties and let's protect the public domain against further incursion, there is a sort of a body of literature that says that traditional knowledge, folklore, and plant genetic resources are essentially being appropriated by Western commercial entities. They sort of look at it and they say, there's no intellectual property rights here because it doesn't fit with our traditional notion, so we can raid at will. And so, to the extent that people like me are saying, gee, we should really preserve the public domain. Pam, do you think traditional knowledge is in the public domain? Sure. Do I think folklore is in the public domain? Sure. Do I think plant genetic resources that are kind of out there in the world, are they in the public domain? Yeah, of course. But I think that there is something to be said for the claims that there's some unfairness about uncompensated takings. And so this should temper perhaps our both domestic and international conversation about, let's get a treaty for the public domain, because I think that we at least have to think seriously about how we should respond to these initiatives to get some meaningful compensation and some right of control over the uses of some of these traditional knowledge type artifacts. Zone of broad usability is, Bankler was the one who I think got this particular idea started, which is let's include every sort of fair use and thing that you sort of feel like you should be able to do in the category of public domain. And we can give lots of examples. The World Wide Web is probably the richest example of sort of a zone in which, right, you go on the World Wide Web and you just, you want to download a page, you download a page. If you want to sort of copy something from off you do. And there's a kind of sense in which, yes, of course, that's part of what we experience as a public domain as users, even if, strictly speaking, from the IP-free definition, it doesn't qualify. And I think that there's a lot of important resonance there. Beyond that, there is sort of even kind of broader conceptions of public domain. Michael Bernhack, in an article that's forthcoming in this University of Amsterdam volume, really thinks about public domain and really defines it as a sphere of communication. And so really has a very broad understanding of the need, if you're going to have a deliberative democracy, to have a domain in which people are free to share information and information artifacts to inform themselves and to express themselves in a wide-ranging social discourse. And that just means, I think it's consistent with the zone of broad usability that Bankler was talking about it, but I think extends the metaphor out even farther and connects it to democratic theory and free speech theory in ways that are at least very interesting to think about. I'm going to suggest that David Lange has two conceptions, one from 1981 and one from 2003, which are different and very provocative. Number one is a kind of what I'm terming, and forgive me, David, if you don't like it, a zero-sum game, right? The sort of notion that there's this landscape out there, and any expansion of intellectual property rights is by its very nature a kind of contraction of the public domain. So every time intellectual property rights expand, the public domain shrinks, and that's kind of a zero-sum game and a way of thinking about it. David, you're partly responsible for my map because to the extent that you use words like sanctuary and refuge, I was like, let me sort of create this little zone on my map, which really would serve as a kind of refuge or sanctuary, and some of those borders would really be impermeable, because some things really needed to stay in the public domain and not kind of go back over the fence. But in a really interesting essay published in the Duke volume, David talks about the public domain as a status that arises from the exercise of creative imagination. And again, this is a different kind of metaphor for what public domain might mean, and it presumptively would privilege creators to appropriate from other works to create their new ones. I think it raises an interesting question, which you don't totally answer, which is sort of who qualifies for this privilege, right? So are we all authors, or do only some people kind of qualify for creators as creators, and do they have some special privilege to appropriate that other people don't? And I think that's an interesting set of questions, but it's a set of questions that's generated off a different conception of what the public domain might be understood to mean. Julie Cohen, in a forthcoming work, I think offers some similar views and really characterizes the public domain as a kind of cultural landscape within which we create. And I think that part of the sort of difficulty of my map is sort of assumes that the public domain's over here and copyright's over here, when in fact there's more. Right, part of this sort of effort, I think, by David's and Julie's is to push back the border of copyright a little bit and sort of find a place where there's kind of some intersection there, where of course you're drawing upon existing work, but all work does, and that's actually a really positive thing. So I think that these are really important kind of to direct our attention to what is it that makes creativity happen. And I think that some of the old discourse about public domain really confines that in a way. And so I'm really glad that Julie and David have been reimagining public domains in terms of creative practice and the importance of kind of serendipitous appropriations. There are many things that show up in volumes about the public domain that are about contractually constructed commons, and these too are enormously different from the kind of the old-fashioned IP free zone concept of the public domain. But I think that as intellectual property rights have become more common in many of the scientific and research fields, patents and copyrights and in some sectors database rights, the question about how you preserve some of the norms of open science within an IP-intensive environment has given rise to sort of a discussion about how can you configure the intellectual property rights essentially to preserve public domain values. So you can construct your own kind of commons. So it's a limited common property right within that commons, but this community of scientists who are in need of being able to use that information will be able to participate in the commons and continue to use it in ways that will promote innovation. But it's a way of sort of, in some sense, a reaction to propertization. But I think it's actually, again, something that expands our notion about how can we preserve public domain in some meaningful sense, even if we're going to try to mix intellectual property rights with it. And of course, open source and Creative Commons are other kinds of contractual. I think the broadest meaning of public domain is one that I found in an essay that Brad Sherman and Wiseman are using, and again, one of the essays that will be in the public domain book of coming out of University of Amsterdam. They actually use it, and they're not alone in doing it. So as to say that the public domain refers to information resources that are widely available, whether they're encumbered by intellectual property rights or not. And they focus our attention on the need to focus on the accessible information, right? If something is free of intellectual property rights and yet it's not accessible, then it's not really meaningful to say that it's in the public domain. And there are ways in which you can make information accessible, and accessible in a broad way, while it is nevertheless encumbered by intellectual property rights. And so sort of thinking about accessible information and how it can be how the accessibility can be preserved so that progress can continue. It's, I think, a similar but not identical strategy to the one that Jerry Reichman and others have been trying to focus on with contractually constructed commons. So that's the zone. And I'm going to go through this real fast. So what are the payoffs of having a broader or a multiple meaning of public domain? I think there are a couple. These are, to me, minor, but nevertheless, I think worth mentioning. It avoids people having unnecessary and really fruitless conversations about my public domain is the right one and yours is the wrong one. This is like not a way to kind of have an interesting conversation. And you're just dancing on the head of the pin, the angels dancing on the head of the pin problem. So if you kind of accept that it's actually legitimate for other people to use a word that you like in a way that you don't use it, then that actually just means let's not fight about that. Let's fight about something else. But I think also it avoids pedantry. And this is where I confess I'm an old-fashioned intellectual property person, right? I look around and sort of say, oh, well, this thing that you use, oh, that's actually in the public domain, right? And this other thing, oh, it's a fair use, so yeah, you can do it. And this thing over here, well, it's like singing in the shower. It's not in the public domain, but it's unregulated by copyright, so it's okay. And it's like a pedantic, boring way of having a conversation. And so the thing that Lessig, Benkler, and I think Boyle have helped us sort of see is that let's just talk about public domain as a kind of our normal expectations for broad uses of information, and that actually means that we can have more fun, and we can also build a broader base of people who are concerned with public domains because they care about being able to make use of information, use things on the World Wide Web, and the like. I think the other thing, and this goes back to, I think, Jamie's hope, which is that we can begin to develop context-sensitive usages so that you know that when I'm talking about X being in the public domain, that I'm talking about IP-free zone, and when I use this other term. So some of it actually is based on speakers. So when James Boyle is talking about the public domain, he and David Lange don't mean exactly the same thing, and so it's useful to sort people out in that particular way. But also, there are there are public domains being discussed that have different statuses, and it really helps to actually sort of set things aside and sort of start developing a richer discourse about things that are in public domains and kind of what their status is and why that matters. And I think it also, the context-sensitive usages, I think can partly be built around the interests of various communities. So I see several different kinds of communities, in the material that I've covered so far. I think David Lange and Julie Cohen are in particular interested about the interests of the individual creators, mostly on the copyright side here, but nevertheless, interests of creators. Because we want that ongoing creation, we need to configure both intellectual property rules and public domains so that we get that cycle of innovation happening. Reichman and Rye, I think, are more interested in the scientific communities and ways in which public domain and either contractually constructed commons or other strategies can coexist with intellectual property rights. And I think there's some more nuanced answers that we can give to certain questions once we sort of accept more than one definition. So, if you ask the question, is the public domain shrinking? Well, it really depends on which public domain you're talking about, because, right, depending on which one it is, it can be expanding, and so I think that helps. Similarly, with public domain and the commons, are they the same thing or are they different things? Well, again, it sort of depends on what you mean. So one use of commons and one use of public domain involves a significant overlap because they are zones within which information resources can be used without charge, without restriction, and that's a place where people can play. But an information commons may also be a public domain in a different sense, where it promotes public domain values such as access and broad usage rights, even though, strictly speaking, it's subject to intellectual property rights, other kinds of regulations, and even perhaps some fees. I also think that what it does is it gives us more things to imagine from. And so the multiple meanings of public domain then really allow you to sort of riff off different kinds of metaphors, and I think generates more interesting conversation and allows you to sort of conceptualize public domains in a kind of a richer way. And so I thank you, those who invited me, for the opportunity to enrich my own understanding by going back and rereading everything and sort of realizing that my own understanding had been crabbed. So that's a good thing to know. I think it's also given us an opportunity to sort of think creatively about institutions and to appreciate that there's more than one way to serve public domain values. So things like the Project Gutenberg and Eldred Press really are aimed to promote access to intellectual property free texts, but the Internet Archive just promotes public access. And if you talk to Brewster Kahle, who is a developer of the Internet Archive, he thinks that he's promoting the public domain by making very, very much stuff available, even though, again, in the old strict sense, public domain is not. Similarly, there's more choices that are available. You can think more broadly about what strategies to use and what kind of institutions to construct to serve those values if you're not sort of just saying, oh, the public domain is only this one small thing. I think, the variety of choices with Creative Commons licenses, for example, really means that there's just more possibilities for sharing, and that then increases, I think, meaningfully public domain usages. And of course, the institutional considerations. Some types of information resources really need institutional management in ways that other resources don't. And so you can still construct a commons in a way that will facilitate those public domain values, and I think that's really terrific. So, in conclusion, I agree with Jamie that until relatively recently, the discourse about public domain was pretty weak, especially if you compare it to the discourse about property rights. And I think the weakness is really now, I'm again confessing, the weakness is partly due to overly narrow conceptions of the public domain as the IP-free zone. And that's the only thing that you can think about. It's actually boring after a while. And so I think that this new body of scholarship and this new conversation that's happening has sort of been generative, and partly because it's accepting, or it can accept more than one definition. My final observation is maybe it's time to take the out of the public domain. My husband's from Ukraine, or from the Carpathian Ukraine, so initially. So, it used to be called the Ukraine. They said, the country's name is Ukraine, okay? We don't talk about the property, right? We talk about property. So maybe we need to take the out of before the public domain because we mean more than one thing now, and the I think is misleading. So with those thoughts, thank you for your attention.
Pam, if you are not too tired, and we'll take a few questions.
Sure.
Do you want to just recognize people as they hold their hand up?
Okay.
That would be fine. This assumes always that they do hold their hand up.
So you've worked at the public domain. What about the commons? Or is that the next lecture? Do we have to invite you back for another lecture?
Take the out of it.
Take the So obviously,
Although it's harder actually. See, with public domain, you can say public domain and then say, well, that means many things, or you can say public domains.
Yeah.
And that's another signal that you're talking about more than one thing, or you're admitting more than one thing. With commons, you got to deal with commonses. This kind of sounds a little goofy. But yeah, I think I'd take the out of the commons too, or develop essentially a context-rich understanding of commons one being the sort of the zone of without restriction, right? Widely accessible, without restriction in terms of use or reuse, and without charge. So that would be commons one, and commons two would be the more contractually based or other kinds of.
because the thing that interests me here is, as you know, in my own work in trying to make sense of it, I've tried to say that we should understand these terms as trying to describe intellectual properties outside or control over knowledge is outside from the status of a particular fear, something that we're frightened of. So if what you're frightened of is people charging too much for it, then you imagine it as the realm of the free, as in no cost. If you're frightened about someone having control over it, you don't actually mind paying for it, at least some reasonable amount, but you don't like the idea that someone could, say, no, you may not come in, then obviously the public domain or the commons looks very different. Then you get something much more like Terry's liability rules, or the idea that of compulsory licenses, the idea that we're not worried so much about the fee. The idea is that someone might be able to block access. That's what I'm worried about, control over an operating system, for example, an API. And if what you're worried about is hierarchical creativity, then what you might want is the idea of a commons where people are actually restrained. No, you can't take the software and re-privatize it. No, you actually have to give to other people the same freedoms as I gave you, which is actually deliberately not leaving you free. In fact, I'm trying to control you quite specifically so as to make sure that everyone can build together in the future. So that's my sort of loose and unsatisfactory way of thinking about these things, that we should think about each of them as a way of avoiding a fear or enabling a hope. In your story, you gave us really all the kinds of fears and hopes that public domain might speak to. Do you see commons as fitting exactly into the same thing? Do you see it as somehow in a separate realm? Is it the evil twin of the public domain? I mean, how does it fit into the story?
For me, they're overlapping circles. I think there are some things that commonses do that don't necessarily serve public domain interests. So you can have people who have, the real property example is the limited common property right that you have if you have a condo and there's some common space. You all have some interest in that common space, but that's a very different kind of commons than we're talking about in respect of the information resources. And I think that there are probably some I'm going to have to think about this a little bit more, but my hunch is that there are probably some things that might fit within some definition of information commons, but that actually are not aimed at promoting the public domain values. So that's why I'd like to see them as really kind of different. overlapping but different. Jerry?
I think it was just really very fruitful and full of resonances. You're working through the system this way. I think it's wonderful for all of us. Building on what Jamie says, I think Commons idea is interesting for a number of reasons. Partly because you are talking in terms of property without the, so you have these interesting interrelationships between rights that support access rather than impede access. And the other thing that's interesting about the Commons idea is that it's very old, whereas lots of people think it's very new. And the third thing that I think perhaps you underestimate, or I know you don't underestimate, underemphasize in your, is that the Commons principle, the old notion of Commons principles, which you and I have written about, and you and in the reverse engineering article, is that it's inherently pro-competitive. And I think that's an aspect that we can lose if we get too carried away with pure public domain discourse. There's another aspect to it. And I think that's really true both in the national and international environment. Losing that public domain environment, losing the fact that in a worldview, TRIPS is antagonistic to GATT, and we ought to be thinking about that, can be captured in the Commons principle as well as the public domain, but needs to be there.
Yeah, I think that's right. Let me sort of use that observation to kind of come back and respond to something else that Jamie said. If you think about open source software as a kind of commons or as a kind of institution to promote public domain values, of course an important part of that is that it enables competitive build-upons, right? That it enables competition, and that means that people will have more choices, and it also has other values that are associated with non-monopolistic platforms, and that's lower price and kind of ability to adapt to one's own uses. And it really makes more people able to be creators. I think that one of the most important things that I've learned over the last couple of decades really is how generative information technologies are, right? More users of information technologies themselves become creators than is true for the old-fashioned kind of single-purpose technology, right? You buy a toaster, you use it as a toaster, right? But you have a general purpose device and with software, and you can build things on top of it. All of a sudden, my God, I can do this, I can do that, I can do this, and I can do that. And so they're really generative of creative activity by a wide array of people. So I think that's really a valuable part of it. But I don't want the whole world to be like open source bound. There is something really terrifically wonderful and competitive, actually, about the real public domain, right? IP-free zone, because then you can take works out and you can really refashion them to make new things. And so trying to sort of figure out where are the kind of pro-competitive strategies for the use of open source like concepts, and where in fact do we really value having this IP-free zone, so that if I want to sort of mount a production of Carmen, for example, I can do that, and I can actually do it differently than the original creator of that opera might have wanted, and so that's actually again a good thing for there to be this IP-free zone, and not. So I think that thinking about pro-competitive strategies on both sides of those fences is really very important. Yeah.
I was really attracted by your explicit political agenda, which was kind of a first do no harm kind of advice to Congress. Before you go out and create more rights, think about whether they're actually doing what you want. I'm very curious how you think about how we would know that. And very specifically, 25 years ago, we did an experiment, which was kind of pass this law, and let's say a lot of stuff that would have been done in the academic realm and probably would have been in the public domain in your classic sense isn't anymore as a consequence of that. How do we know whether that was a good idea or a bad idea? And based on that, if that's your criteria, we got to know that it's doing good before we do more of it. What do we do with that? How do we know?
There was a very interesting essay written some years ago in another symposium that I think David and I were participants in which Robert Kastenmeier, a then congressman, and Michael Remington, his then chief counsel, wrote, which basically was recounting the experience of the Semiconductor Chip Protection Act, which was a new form of intellectual property protection that was created, and they actually put together a test for when should legislatures act to create new intellectual property rights, and what kind of evidence should they offer, or should they have before they go forward with this. I think they felt that at the time that experience was actually that they had followed that test, but that it set a pretty high hurdle, and unfortunately, it didn't get followed. Years later when the Vessel Hull Protection Act came forward. But that's, I think that there are, that would be the place where I would start to come up with kind of the checklist of things that Congress really ought to be requesting. And I think that this really is a time when we can reflect on, what have been the successes and the failures of these regimes and extensions of rights. And I think we can say the Semiconductor Chip Protection Act was just not really a successful law. And I don't think actually there's a lot of debate about that particular one. I think there would be no debate within the academic circles about the Vessel Hull Protection Act. It's an embarrassment, and I think that. One of the things that's really interesting about the database protection directive in the EU is now that they have had several years of experience with it, has it really caused their database industries to go, take off? No, it's like, our industries are still doing better. So there's something going on there besides intellectual property rights. And I think that kind of empirical data, and people are collecting that now about these kinds of experiences, I think really does serve to inform the legislative conversation. Artie?
Actually, picking up on that last comment, that might suggest having lots of diverse regimes rather than necessarily, to just play devil's advocate, adopting a commons or public domain approach to regime everywhere, but rather running the experiment in different ways, because unfortunately it's impossible to know until one runs the experiment and gathers the data. So perhaps we should be more agnostic as to the choice until we run the experiment. How would you feel about that possibility? And so have certain countries with high levels of protection and other countries with lower levels of protection, and then do a compare and contrast.
I think it would really be interesting, and I think that we could actually already do that in respect of a lot of things, because there are lots of things that are different. There are lots of things in the public domain here that are not in public domain elsewhere. And I know that one of the national and international conversations has to do with protection of legal information, right? So legal information is something that's really considered to be fundamental here. I think that the courts have treated legal information, whether it's statutes, regulations, judicial opinions, or whatever, as public domain material. And we have one particular market that exists with that material all being in the public domain, and other countries have that under control and under intellectual property control. So we could do, it's like, to the extent that we buy into this, like, it should be in the public domain because it's essential by its very nature, you sort of say, well, it's not necessary to a democracy because, other countries are actually living, that they're democracies and they nevertheless protect their laws by copyright. But I think some fruitful comparative analyses could be done, both in sort of the legal structures and also in the market structures that exist in those domains. And I think that would be fruitful to study. Now, what about, let's have, the U.S. pass an intellectual property law for this set of things, and this other country decide not to, and let's run a controlled experiment. Part of the problem with that is once the intellectual property rights get on the books, I've never seen anybody repeal one. So, and the sunset provision that was put into the Vessel Hull Protection Act, which was put in there in order to sort of express some skepticism about whether there truly was a need for this form of intellectual property protection. Well, the next session, the legislature, or soon thereafter, the legislature repealed but they didn't repeal the intellectual property statute, even though it's essentially been used by about 2 or 3 people. They instead, took away the sunset provision. So now we have an intellectual property statute on the books that's essentially meaningless, and really that's true with the semiconductor law. I think today we could repeal the Semiconductor Chip Protection Act, and it wouldn't affect the semiconductor industry at all. But now we're bound to it because it's in the TRIPS agreement.
When I think about your concept of having multiple context-sensitive meanings in the context of Professor Boyle's second enclosure article, I kind of think about 2 shepherds talking to each other, and one says, "Oh, do you really feel like the commons is shrinking?" And the other one says, "Oh, do you mean the one north of the city or in the center?" I mean, kind of in that vein, do you mean in the modern day when 2 people are talking about the intellectual property commons, should one say, and one says, "Oh, do you think it's that there's a really big and vibrant public domain or commons?" Pardon me for crossing my public domains and commons. Should the other person say, "Well, do you mean the medical commons, or do you mean the medical Christian commons, or do you mean the cultural commons?" Is that what you mean by sensitive meaning?
Yeah, I think that's right, and I think it does. It makes us be more honest by taking and more open-minded about what other people are talking about, and I think we can create some interoperability among these concepts. But yes, I think that people should say, well, if you're saying this, then the answer really should depend. So one of the questions that I was reading in the literature as I was preparing for this talk was, is the public domain revocable? Can you revoke something from the public domain? And it depends on what you're talking about, So I think that there are some things that are revocable and some things that are not. And it's actually good to sort of distinguish among those things. And so I think it does mean that we're going to have to do a little bit more work, but just as Jamie is confident that property people are able to do that with facility, that what we need to do is just build up a little bit more these multiple meanings and accept them and share those wider meanings, and I think we'll be able to do it too.
We should perhaps stop
Okay.
at this point.
Thank you so
Tammy,
much.
this is very kind.